The real property question from July of 2008 is easier than it looks. Have a look at the call of the question. There are three parts. 1. What are the property interests of Betty and Ed, if any, in the condominium unit? Discuss. Well, it's pretty hard to outline an answer to this call of the question, but it is possible to anticipate that it's likely we are going to have to trace a series of transactions in order to figure out what the respective interests of these parties are. Question 2. What relief, if any, may Ed obtain on his claims against Betty for past due rent of her use of the condominium unit and for a share of the rent paid by the tenant? Discuss. Well, this is a pretty simple civil remedies call of the question. Ed is going to have one or more theories of liability, and these are going to have to justify his claim for damages in the two forms that he's seeking. So we're going to have to examine the facts and act accordingly. And then finally, question 3. What relief, if any, may Betty obtain on her claim against Ed for contribution to the costs of maintaining the condominium unit? Discuss. Well, here again, we've got a pretty simple, straightforward civil remedies call of the question. Betty is going to need to have a theory of liability, and she's going to need to have one or more prayers for relief. So our answers to questions 2 and 3 are fairly easy to outline before we read the fact pattern. However, this is one instance where that effort at outlining actually doesn't end up doing us any real good. Now go to the top of the question and let's try to sort out all of these complicated facts. In the very first paragraph, we meet Anne, Betty, and Celia. And the only one of these three that we've heard of in the call of the question is Betty. These three women buy a 3-bedroom condo and they all live there. Each of them pays a third of the purchase price, and at the end of paragraph 1 we find out that they take title as joint tenants with right of survivorship. The full magic words in order to create a valid joint tenancy. In paragraph 2 we find out that Betty moves out after a dispute. Does that act break their joint tenancy? Answer, no. Then we see Anne and Celia each executing a separate deed and each of them conveying their interest to Ed. And take a look at the language. Basically, each of them retains a life estate. Anne and Celia keep a life estate, and the buyer gets a remainder. And we also find out at the end of this paragraph that Anne records and delivers the original deed to Ed. Celia also records, but leaves the original with Anne in a sealed envelope with written instructions. Okay, well obviously we're going to have to analyze these facts fairly carefully, but it boils down to a series of transactions involving conveyances by deed. And take a look at the last couple of lines here in paragraph 2. Celia records, but only to protect her own life estate interest. Well, just because that's what her own personal subjective intent was, doesn't mean that her recording might not have other legal impacts. Then in paragraph 3, Anne and Celia both die in a car accident. No wonder they're not in the call of the question. And at that point, Betty moves back into the condominium unit. Has she got the right to do that? Answer, sure. She's a 1/3 joint tenant. Although, after the death of Anne and Celia, and given that there have been deed conveyances from Anne and Celia to Ed, obviously it's a lot more complicated than that. Still, there is nothing in these facts that suggests that Betty doesn't have the right to move back in. And look at what she does. She rents out one bedroom to a tenant, and she uses the other bedroom to run a computer business. Obviously, Betty is sleeping in the 3rd bedroom, and she pays all the costs of repair and maintenance of the unit. Okay, has Betty got the right to occupy this condo? Answer, yes. Has she got the right to take a tenant? Answer, yes. Does she have to share that income with Ed? Answer, yes. So we see Ed commencing an action against Betty, demanding a share of the rent that she's collected. Has he got the right to do that? Yes. He also demands that she pay rent for her use of the premises. Well, that is a much sketchier claim, to put it mildly. Then we see Betty cross-complaining against Ed, demanding that he contribute for his share of the costs of necessary repairs to maintain the unit. Okay, well, let's just think about that for a moment. If Ed is demanding from Betty a share of the rent that she is collecting, something that I think he does have the right to do, it seems entirely reasonable to me for Betty to expect Ed to contribute a similar share of the upkeep costs. And then we get the call of the question again. And as we pause for a moment to think about this call of the question, one thing that we recognize is we're definitely not going to have to do a full remedies analysis to answer questions 2 and 3. Actually, these are pretty narrow questions in the context of the facts as we have just read them, and our answer to the first call of the question will make it much easier for us to answer the second and third calls of the question. We see in looking at call of the question number 1 that an answer to that question will require us to go through all of these fairly complicated transactions. So turn the page and have a look at the outline of issues that I've offered, and I think you're going to see that this probably is a classic example of using the facts as an organizing principle. In order to resolve the property interests of Betty and Ed, we've got to go through all of these earlier conveyances. And you know what? We're going to see questions exactly like this in the law of wills and trusts, which often requires us to go back through a number of different transactions in order to resolve the rights and possibly the remedies of various claimants. Well, it's a very similar analysis here because we're dealing with the property interests of Betty and Ed. And in order to figure out what those are, we've got to start with Anne, Betty, and Celia buying the condo as joint tenants, and then just following the chronology. I'm not going to bother to read it to you here. We just went through it in the fact pattern. But take a look at the bottom line. Ed gets 2/3 of this condo, and Betty has a 1/3 interest, and they are tenants in common. And the actual legal reasoning required to reach that result is no more complicated in this essay that we have 1 hour to write than it is in many real property MBE questions, which we have roughly 1.8 minutes to resolve. So the law required to answer question 1 isn't hard, but the factual analysis could be very intimidating. But notice how my approach of using the key facts as headings makes it very straightforward for us to do a precise, thorough analysis of these facts, reaching the conclusion, which is, incidentally, the correct answer to the black letter law question presented. Now, in examining question 2, Ed versus Betty, notice that my outline is no more complicated than we were able to intuit from our most basic reading of the call of the question. I skip Ed's theory of liability in the outline, and I just go to his remedies. The question is asking if he can get past due rent from Betty and a share of the rent from the tenant. I'm prepared to give straight answers to both of those questions. Then as we consider Betty versus Ed, I conclude, ultimately, that she probably doesn't get to recover. But I do recognize that it's a close call. And as we get to the very end of a review to my answer, I really do leave it fairly ambiguous. I understand that this is a complex situation and that Betty might actually have a valid claim. Now turn to the answer to this question. And one thing I want to say to you up front is this isn't a very long answer, and it's also a very simple answer. The questions presented just aren't very complicated legally, but they are factually intricate. Notice that what I start off with here isn't the facts. I don't lead with the facts this time. I lead with a one-sentence statement that in order to determine the property interest of Betty and Ed, we've got to examine the chain of title. And then, notice, I go very carefully through what happened. And with regard to discussing Anne, Betty, and Celia, notice that I start off by talking about what a joint tenancy is. You know, I've already said a couple of times that there isn't a great deal of law in this question, but you'll notice that I do discuss a lot of detail about that fairly small amount of law. Notice that I define a joint tenancy. And also notice that within my analysis in section 1A, I indicate that the unities of time, title, interest, and possession all are present. So it's conceivable that one could organize part of the analysis around those elements. But to me, it just seems so much more intuitively sensible, not to mention easy, to organize chronologically and go through the facts. Then I focus on Betty's act of moving out. And the reason to analyze it carefully is because if her act of moving out severs the joint tenancy, it could affect some of the relationships later. But clearly, her act of moving out, particularly when interpreted in the context of her later reoccupation of the property, certainly suggests no severance. Then I focus on the deeds to Ed. One could readily blend this analysis and talk about Anne and Celia in the same paragraph. But it seems to me that it is easier to do them separately, and also there is at least one factual distinction with regard to Celia. Remember, we're told about her sole intent for recording, being to protect her own interest. But it also has the effect of protecting Ed's remainder interest, and recording the deed is likely to be deemed a constructive delivery to Ed. And so all of this means it all adds up to Ed having a remainder interest in Anne and Celia's shares of the condo. And now the joint tenancy is severed for sure. And right after that, Anne and Celia die. Their life estates don't last very long. And so at that point, Betty retakes possession. And I indicate exactly how she retakes possession. She occupies 2 bedrooms and rents out a third to a tenant. Has she got the right to do this? Absolutely yes. So I conclude at the very end of my lengthy analysis to question 1, Ed has a 2/3 interest and Betty a 1/3 interest as tenants in common. And I think that's the correct answer. Then we move on to consider the other 2 lawsuits. Ed versus Betty is a fairly complicated action, not because the questions presented are tricky, but because we've got to be sensible enough to split it up and consider each claim separately. So with regard to the past due rent from Betty, well, Betty never owed any rent. She's an owner, so there is no past due rent. She's free to occupy the entire condominium. However, to the extent that she took rent in from her tenant, well, under those circumstances, as a tenant in common, she has to give Ed his pro rata share of income. So even though Betty is technically occupying the entire condo, the only part that she's got to convey to Ed is 2/3 of the rental income. And that's what I conclude. Ed doesn't get rent from Betty, but he does get 2/3 of the rental income. That leaves us to call of the question number 3 to respond to, and at this point we see that call of the question number 3 is by far the narrowest and simplest question, and I answer it very thoroughly in 2 short paragraphs. And first what I do is I lead with the facts. I explain that Betty paid all of the costs to maintain this condo, and that she has cross-complained against Ed seeking contribution for his share of her maintenance expenses. But since she is occupying the property alone, I think she's responsible for these expenses. And if she were by herself, there wouldn't be any question about it. She wouldn't be able to recover. But I do recognize that Betty's claim is strengthened by the fact that Ed wants 2/3 of the rent from this tenant. And that's within his rights. And it does seem to me that it strengthens Betty's claim. So that wraps up a discussion of a fact pattern that is complicated, but which doesn't really raise many complicated legal issues. Once again, the key is factual analysis.